5 seconds to go. Start. In Rijan and another versus State of Chhattisgarh through the Chief Secretary, Government of Chhattisgarh, Raipur, Chhattisgarh, this court has observed that the accused need not prove the existence of private self-defense beyond reasonable doubt, and that it would suffice if he could show that the preponderance of probabilities is in favor of his plea, just as in a civil case. In State of MP versus Ramesh, it was observed that no useful purpose would therefore be served by referring to them over again. All that need be said is that whether or not a right of private defense of person or property was available to the offender is the very first question that must be addressed in a case of the present kind while determining the nature of the offence committed by the accused. Whether or not a right of private defense was available to an offender is in turn a question of fact, or at least a mixed question of law and fact to be determined in the facts and circumstances of each individual case that may come up before the court. To sum up, the right of private defense is necessarily a defensive right which is available only when the circumstances so justify it. The circumstances are those that have been elaborated in the IPC. Such a right would be available to the accused when he or his property is faced with a danger and there is little scope of the state machinery coming to his aid. At the same time, the courts must keep in mind that the extent of the violence used by the accused for defending himself or his property should be in proportion to the injury apprehended. This is not to say that a step-to-step analysis of the injury that was apprehended and the violence used is required to be undertaken by the court, nor is it feasible to prescribe specific parameters for determining whether the steps taken by the accused to invoke private self-defense and the extent of force used by him was proper or not. The court's assessment would be guided by several circumstances, including the position on the spot at the relevant point in time, the nature of apprehension in the mind of the accused, the kind of situation that the accused was seeking to ward off, the confusion created by the situation that had suddenly cropped up, resulting the in knee-jerk reaction of the accused, the nature of the overt acts of the party who had threatened the accused, resulting in his resorting to immediate defensive action, etc. The underlying factor should be that such an act of private defense should have been done in good faith and without malice. Being mindful of the aforestated parameters, we may examine the plea of self-defense raised by the appellant in the attending facts and circumstances of the case. The factum of rampant smuggling in the area has not been disputed by either side. The records reveal that border fencing in the area in question had been erected just a few months before the incident had taken place. Stop.